Good morning. We are in Senate Judiciary. It is February 13th. We have led Counsel Fitzpatrick with us going over an amendment to S3. And Eric, the floor is yours.
Thank you. Thank you, Senator Hashim, and good morning, everybody. Eric Fitzpatrick, as the chair said, with the Office of Legislative Counsel here to go over a possible amendment to S3, which you may recall was an act relating to the transfer of property to a trust. Remember, the general big picture of it is that it provides for some legal consequences for property being transferred to a trust when the property is held as tenants by the entirety, which is a part of joint property ownership. When more than one person can own property, it applies specifically to spouses, people who are married. So spouses transfer property that they own as tenants by the entirety into a trust. It retains a certain quality that it has beforehand, and that quality is known as creditor protection. So if spouses own property currently as tenants by the entirety, a creditor of one spouse is not able to get at or attach the property because of the fact that the wrongdoer is only one of the spouses. So again, because of the nature of the way that they own the property, they each own what's known as an undivided 100% interest. They're immune from the creditors of one spouse. Now, if it were joint creditors, that'd be something different. Of course, then in that situation, they could get at the property. But if it's only one of the spouses individually who is owing the money, then it can't be attached by a creditor. And that's the same thing as it is currently when property is owned by spouses that's in tenants by the entirety. This provides clearly that if the spouses decide to transfer the property into a trust, it retains that feature, keeps that creditor protection that it had before it was transferred to the trust. So that's kind of the big picture of what's going on in the bill. It also allows, as with trust generally, when property is transferred to a trust, has a benefit as well in that it can then pass to the beneficiaries of the trust without having to go through probate. So it avoids the probate process as the other benefit of putting property into a trust as opposed to keeping it outside the trust. So you have before you now a proposed possible amendment that has been discussed by the parties. Remember, you had a couple of witnesses as well as some discussion going on with interested parties after the committee took up the bill last time. And there's my understanding, I don't want to speak for anybody, but my understanding is that the parties have agreed to the bill as amended, and at least in one instance, which I'll explain, the decision not to ask for an amendment. But I can pause for a moment and take a look at what the proposed changes are, Senator Hashim, or I can hold off if there are questions now, whatever you think.
I think one of the main questions that I just wanted to reiterate or re-clarify is the creditor protection when if it were to be applied to the estate, and one of the spouses dies and there is a beneficiary, that creditor protection doesn't pass also to the beneficiary, right?
I think that's correct, right?
Okay. That was just the main question I had to reiterate. And if yes, please continue.
Well, it's actually nice segue there too, the reference to the beneficiaries, because you may recall that another issue I think the committee had been discussing was this idea that kind of similar to what you were just saying, Senator Hashim, that the benefits that the beneficiary may have. And I think the committee was also concerned that the creditor protection, as you said, wouldn't exclusively go to just a beneficiary as opposed to remaining with one of the married spouses, which is, the way that the law currently works, and I think is the intent of the the creditor protection in terms of the spousal relationship. So there was discussion about that, and you may recall, and this goes to some slightly amended language on page 2 of the amendment. If you have it, it's highlighted in yellow at the very bottom of the page, because the response had been that yes, the benefit wouldn't, the creditor protection rather, wouldn't just go to the beneficiaries, because I'm looking at for a moment, I guess, before we look at the highlighted language over on page, well, it does start at the bottom of page 2 and go over onto the top of the next page. The way the language had read, I think the idea, the intent was to say, oh no, the spouses still have to be beneficiaries of the trust, right? So it's not just going to be, it wouldn't be who other people who might be beneficiaries, whether it's the spouse's children or some other person who they decide they want to be a benefit to receive the benefits of the property in the trust, whoever the designated beneficiary is. The spouses themselves also still have to be beneficiaries of the trust. And that was the idea. And I think it went to the committee's concern about, well, we don't just want to be extending this creditor protection to whoever the spouses decide are going to be the beneficiaries of the trust. It's really a feature or a benefit of the marriage relationship, the spouse relationship, so it should remain with them. And so that was the intent. And you'll see that over on the top of page 3 again, the requirements that in order to create this thing, it says both spouses are current beneficiaries of the trust, or each spouse is a current beneficiary of a separate trust, and 2 separate trusts, et cetera, hold the property. So either way, the point is that the spouses do have to remain the beneficiaries, or at least that was the intent. You may recall that I was noting that, well, that it didn't read right to me. This goes back to line 20, page 2. That including if language is what was throwing me. It didn't seem like it really said that. So the agreement was to just strike that language, change it to and. So it makes clear that one of the requirements for this to work is what I just read. It's not new, but now renumbered as subdivision E, and it's set out separately by use of that term and. So yes, it's required that the spouses have to be the beneficiaries. Does that make sense?
Yes.
Right. I
want to speak for the committee. To the committee, does it make sense?
I mean, it doesn't make less sense than it did before.
Yeah, Eric, I'm trying to grasp this whole situation here. So when we have a husband and a wife who have entered into a trust and have named like their children 3 or 4 beneficiaries, upon death of one of the husband or the wife, this protection still rolls to the remaining spouse, correct? And upon the death of the second parent, say you get the 3 or 4 children who are listed as beneficiaries and they now have the property or whatever is listed in this trust. Do they have that same protection? Do they have to put this, it's in a trust, so do they have to put this into a trust? Should they maintain this same protection, or?
I didn't quite follow. Did you say that the second spouse had passed away in your hypothetical, or the second spouse was still alive?
Husband and wife have passed away.
They both have.
Yes.
Yes, then no. With the protection at that point, but at that point as well, probably the property would be distributed to them, right? That they passed away.
Distribute the property to the 3 or 4 children, but how do they maintain that? Do they have to start a trust on their own, or what happens there?
Yeah, well, that creditor protection only applies to a married couple, so it wouldn't. Once the second spouse has passed, no, they wouldn't have it. They could, of course, set up their own trust later on to in any sort of contractual way they wanted to try and own the property as they saw fit. But the creditor protection feature of tenancy by the entireties is really specific to married couples. And so once the second spouse has passed away, once the first spouse is still alive, then it's potentially could still exist. But if they're both passed away, then and that's the same case even with outside of a trust, right? It would be the same if the spouses weren't alive anymore.
Okay.
If I can add, I think perhaps and please correct me if I'm wrong, I think the best way to look at it is you have a married couple. They are tenants by the entirety, and they have this protection against creditors, and they're thinking ahead. They want to plan their estate. But then they realize, well, if we actually plan this estate and put it into a trust, we'll lose that creditor protection. So we're not going to do that. So instead, they make that plan to enter the trust. That creditor protection still applies. They both passed away. The property gets distributed, and creditor protection doesn't apply to the beneficiaries, but it did apply back when the two spouses were alive and they were making their plan for their property. Does that sound like a summary?
Absolutely. Yep. I think it's sums it up very well.
Does that kind of clarify?
It actually made sense.
Okay, great. Well, I think, thank you, Eric. Was there more to this?
Yeah, just two other minor things. So you'll see so page 3, you may recall also, I don't want to put words in Chris's mouth, but there was a discussion with Chris Delia about, he was concerned that he didn't want this to override existing contractual obligations. Remember, he brought that up. And so there was a discussion offline. And if you look at lines 9 and 10 on page 3, the creditor protection applies unless otherwise provided in writing by the settler or settlers who transferred the property to the trust. So in other words, if you had an existing contractual obligation that provided otherwise.
Where are you looking, Eric?
9 and 10, page 3.
Yep, lines 9 and 10, page 3. It's not highlighted. It's the existing law. Unless otherwise provided in writing by the settler or settlers who transferred the property to the trust. So that made clear that, hey, if the parties wanted to make a different decision in their contract and have some other set of rules apply, they can do that. And then this won't override a mortgage or a promissory note or some other agreement that the parties had made. And so my understanding, again, I don't want to put words in his mouth. My understanding was that the parties looked at that language and that was satisfactory. So they didn't need to make any changes for that reason.
Thank you.
Yeah. And the very last change is at the bottom of page 3. This is the drafters and the estate planners also wanted to make sure that this creditor protection applied. So let's say hypothetically, a married spouses, a year ago, had transferred their property into a trust. They wanted to ensure that they also got that it was clear that the creditor protection would apply in that situation too, even though they had already done it before the effective date of the act. So that required some additional language to make sure that it applied retroactively. Remember, the legislature can apply legislation retroactively, assuming it's constitutionally permitted. There are some situations where the Constitution will prohibit that, but assuming it's constitutionally okay, then you can do that. And the way we do it is a drafting convention. You see line 18 of page 3. We say notwithstanding 1 VSA section 214, because that's the statute that says, hey, generally, legislative changes apply prospectively. They apply going forward, but they don't apply going backward. So if you want to have something apply retroactively, we have to notwithstand that statute. That's why we say that. And then the new language highlighted makes clear that, hey, this applies also to property that was conveyed before, on, or after the effective date of the subsection. So even if it was conveyed into the trust beforehand, before the effective date, it still gets the creditor protection feature. So I think that's the last change. Yep, that's right.
Thank you.
Sure.
Okay, I think, we are missing 2 members, and also I want to leave this open for a little bit, just in case we get any additional witnesses who reach out and want to express anything about this bill. So perhaps we'll vote maybe tomorrow, probably next week on this, unless there's lingering issues that we haven't resolved. Committee, any questions, comments? Thanks.
I like lines 18 and 19.
Great. All right. So we can, thank you again, Eric. We're going to move on to S61, Brennan's bill.
Thank you, and thanks for being flexible for my Zoom testimony today. Appreciate it.
Thanks, Sarah.
Thanks, Eric.
Yep, thank you.
Oh, yes, okay, names. That might not have that one. Probably not at this point, but. Are you?
Good morning, Senator Brennan. Thanks for coming in.
Good morning. Thanks for having me. For the record, Senator Pat Brennan, Grand Isle County and Colchester. And today in front of you is S61. It's a bill that has been introduced in the past in both the House and I believe the Senate. It deals with section 4013, 13 BSA. And basically what it does is in that section, I'll read it to you briefly. I think you have in front of you a person who sells or offers for sale a weapon commonly known as a zip gun. That stays in legislation. That's illegal. But also in there in the past were suppressors, and also in there currently a weapon commonly known as a switchblade knife, the blade of which is 3 inches long, 3 inches or more in length. So with that, the term switchblade, automatic opening knives falls under that category. And if the chair pleases, I have an example of one if you'd like, the committee would like to see what we're talking about. Sure. It's a tool used by fishermen, contractors, electricians, and construction workers. So it opens, picture an electrician on a step ladder and it's used all the time with a handful of wires, one hand available. He opens it up and it's a multi-purpose tool is what it is. This is what is prohibited by law, being 3 1/4 inches long. And
That is prohibited by law?
this
The one
is
that you're
right.
reading?
This is right on the cusp. Anything longer than this by 1/4 inch is illegal.
Just wanted to make sure on the record that.
We're not breaking any laws.
He's not selling it.
Yeah.
No, and it's no. But this is what we're talking about. And any longer than that, same knife would be illegal. And there are a bunch of them that are 3 1/2 inches. There are no daggers that open that way or, longer knives. Little history, if you got, I don't know how much time we've been allotted, but
10, 15 minutes. That's.
little history. Automatic opening knives are currently legal in 40 states, 29 without restrictions. A ban was passed federally in the 50s, nationally, and was deemed, although it was, this is a little confusing. Michael Gray might be able to help me on this one, but none of the 27 states during that ban, they were still legal for some reason. They passed laws to legalize it. None of those 27 states since the 50s have ever reported automatic opening knife issues, crimes. Still a crime if you're going to pull out one of these knives and use it in the commission of a crime. It's still against the law. They're no quicker to deploy than a legal one-hand opening knife, self-assisted. They open the same. They're desirable as another option for one-hand deployment. Some respects, switchblades can take longer to deploy because they have a safety lock. I didn't mention that. They have a safety lock on them, so you can't hit that button and open it in your pocket or, by mistake. It's an intentional push of the button. Folding knives in general and automatic knives in particular are certainly slower to deploy than a fixed legal blade. And in a survey done by the American Knife and Tool Institute, the common knife used in any commission of a crime it's a common kitchen knife. I don't know what the percentage is, but that's the knife of choice, you know, in the commission of most crimes. So that's it in a nutshell. It's antiquated, the bill. And again, if you are looking at it, I'm not looking to strike the whole section. Zip guns should, in my opinion, remain illegal, and hope they do, but this is just striking that section. There are a number of folks out there in the research I've done on this, that say, when I tell them, let them know what we're talking about here, they say, well, heck, I've got 2 of those at home that they're illegal. They're more than 3 inches long. So it's, and another tidbit, the airport sharps that the state advertises every now and then, on their website, on their auction site, a couple months ago had 4 of these, and they were over 3 inches long. And my cohort at the American Knife and Tool Institute spotted them, and they, you know, reminded the state that, hey, we've got these things, we've been trying to legalize it forever, but you're selling them on the state website. So they were made to take it down, but that's what the bill's all about. I've got folks that are, if you decide to take up the bill, that are willing to come in and talk about it, from American Knife and Tool Institute, an organization called Knife Rights. I've done a lot of work on their 2 separate organizations. CJ Buck is of Buck Knife fame, is the president of the American Knife and Tool Institute. Be willing to testify by phone. He said he'd even fly down to talk to you folks, but that's pretty much what it is.
Any questions, comments?
Sorry, I might have missed it. How many states have the same law where?
40 states exempt. You know, there are currently 10 states, I guess, that you would say they're illegal in, but 40 states allow the use of.
And do you happen to know when our state made this change?
This goes way back. This.
It was like 19. It was one of those, the statute were codified, so it's like 54 or 58, depending on when it was.
1954? Wow, okay.
So was there like a rush of switchblades, Mike, at that time or something between 54 and 58? What was the next, the concern here?
I think the Sharks and the Jets.
Yeah, thank you.
Of switchblades and entertainment, and how they then became part of.
It was not up, but it was kind of the same perception that suppressors had back in the old days when you watched the movie and you saw the thing go off without a sound at all, which wasn't realistic. And like the Sharks and the Jets West Side Story, switchblades they're kind of a thing of the past, but unfortunately automatic opening knives are lumped into that category. And
Yeah, I mean, I can see the, you know, potential for utility in this. I mean, if you're, with the example that you provided at the very beginning of the electrician, or you're a fisherman. I think that was another example you had provided in another conversation.
that worst person, yeah.
Yeah. I mean, I feel like if you have a knife that's 2 3/4 of an inch and you add half an inch on it, it's really not going to make much of a difference. Well, yeah, anyways, those are my initial thoughts. It's, yeah, we'll, reach out to these other folks that you, had mentioned as well. Brady, did you wanna?
So I think the real issue here is there is no definition of what a switchblade is.
Yeah.
So when you have And they're not just referred to as automatic opening knives. Before I came over, I went onto the website of a major manufacturer retailer that sells in Vermont, has a location in Vermont, and they are selling automatic opening knives, but they're calling them one-handed knives. And it was literally, I think it was one of the models I looked at was what Senator Brennan had. But there's no definition. So if a retailer sells nationally, 40 states, they say, oh, is this a switchblade? No, it's not a switchblade, but there's no definition for them to determine whether or not it is.
Yeah, no, I do feel like there was, periods in which switchblades had some sort of, connotation around them as a result of the media.
I did check, it was 1959.
1959, yeah. And so, I mean, personally, I don't have a problem with the bill. I would want to hear, I do want to leave it up, not leave it up on the wall, but, leave it open for a little bit, just to hear what other folks might want to say about it, including the folks you mentioned, but also including any other people who may have a different perspective. Personally, I don't have an issue with it, but we'll just wait and see for a little bit. Senator Norris?
Just one quick question, Mike, are you familiar with, I'm not, in the martial arts or whatever else, they have these,
The butterfly knife.
the knives that open up, is there any restrictions on those in the state of Vermont?
That's ambiguous as well, because you don't have a definition in statute as to whether or not that's a switchblade. It takes very little to open one of those knives. Is that, I don't know, because it's not defined.
Push my button or flick of the wrist, I mean, okay.
But that, I mean, that also, most, and Senator Brennan sees this, I have a little pocket knife in my office. And it has a little knob on it, and I can open it just like that knife opens. Is that a switchblade too? I don't know. So I couldn't tell you because there's no definition.
Yeah. Sort of.
It sounds like there might be a larger problem in that there's no real definition.
And then what I was thinking is perhaps this happened as a result, well, I already said this, but perhaps this happened as a result of just reaction to perhaps an incident that happened or media. So.
And similarly, there's no definition of a zip gun. I had to figure out what that was years ago. It's literally, it uses basically a rubber band to fire a bullet.
Yeah, I was looking up what a zip gun was. The first thing that popped up were improvised firearms.
Yeah.
So
Yeah. Piece of wood with a rubber band
And a bullet or
Oh,
a,
yeah, I mean,
And, you know, they can
I've
get really
never
elaborate.
seen one, but you just pull this thing back, rubber band, and it's obvious it's got a piece of hard metal on it that's gonna trigger the bullet. That's, you can make one out of a piece of wood, and they should be able to, they are, so that's,
so that acts as the hammer.
yeah, that's essentially, yeah.
Interesting.
yeah. Something new every day.
I don't think we have a big zip gun issue anywhere in the States, but,
I don't think anybody's stopping me either.
no.
Committee, any, or Senator Brennan, anything further?
No, nothing more. It's pretty basic. It is what it is, Bill. But I can provide contact information from the two folks I mentioned.
Yeah.
I have it in the other room and I'll get that to you.
Great, thank you.
Yeah, thanks.
Committee, anything further on this? It's pretty straightforward.
No.
Okay. All right,
Great. Thank you.
thank you.
Thanks, Mike.
Thanks for coming down on short notice. I will appreciate it. All right.
Thanks.
Did we have? Oh, yeah. So, with that.
Said Senate floor for the next.
Look ahead a little bit.
Yeah, that
Yeah.
apparently is.
We got time. Yeah, so we are still live. Just so folks know, we had a number of witnesses potentially for S-44. All of them had to cancel perhaps because of the weather. But
Back to this, right?
yes, that was that. And
So is Senator Douglas coming in at 10:30 or?
oh, right. Yeah, we made a number of changes this morning just because we have to rewrite the schedule.
Yeah, it's an old agenda.
So we're not free until 1 o'clock.
No,
Okay.
we might be free earlier, but we're just trying to figure out some stuff here. So.
Or them down. On the other.
There was stuff in Milton, but then like Williston, Waterbury was fine, like Waterbury to here was. Slushy.
That was not as bad as I was expecting it to be.
No,
I got up this morning and was like, some storm.
daycare was closed.
Ooh.
Daycare.
Oh, did you? This weekend is supposed to be possible for Easter, but.
That's fine. I can stay home. I don't have to drive to Montpelier.
Exactly.
We get our copies of S-44, please, and we can go off for a few minutes.
Yeah.